Good morning, Ms. Gooden. Good morning, Mr. Vaca. Ms. Gooden, would you like to reserve any time?
Yes, Your Honor, 4 minutes.
You got it. Go ahead.
Good morning, Your Honor. Kansas Gooden on behalf of the appellant. This court should reverse and remand for several reasons. First, the plaintiff's attorney violated the golden rule by presenting a newspaper or surrogate victim hypo. 2, the plaintiff's counsel disparaged the defense attorney throughout the closing. And 3, the exclusion of a letter of protection. When you look at these individually or cumulatively, they lead to one conclusion, that this should be reversed and remanded for a new trial. And just starting with the golden rule violation, the newspaper ad hypo basically gave the exact same facts as this case, the exact same characteristics, the exact same medical treatment, the exact same age. It gave the exact same everything as the plaintiff. The plaintiff's attorney then invited the essentially the jury to put itself in the surrogate victim's shoes, and ergo the plaintiff's shoes, and to basically have this verdict and the jury to identify with the plaintiff and make this determination on a personal perspective.
Ms. Gooden,
yes.
I have a question for you about the golden rule argument and the case law that is discussed in the briefs. I am having trouble understanding why the Simmons case is not directly applicable as opposed to the puppy story case that, I don't remember the name of it, but the third DCA case with the puppy story. And specifically what I'm focused on, and I need you to address for us, please, is the discussion in Simmons that talks about how the plaintiff didn't ask the jury what they wanted to receive. They just asked the jury to determine how much this plaintiff should be awarded for her injuries. And reading it, I found that to be pretty applicable here. So could you please address how to reconcile those cases and your argument with respect to getting away from Simmons?
Absolutely. Well, and I don't think it's necessarily getting away. I do see it as apples to oranges, because the line in Simmons, which was not objected to actually, was in opening, and it says, to think about what you would pay someone for a day of what you will hear she has to go through for the rest of her life. And then in closing, the plaintiff attorney said, I want to remind you what I said in opening. And the plaintiff, the defense attorney, objected at that point. So it is factually different in our situation. And I point the court to the California case Collins, which dealt with an identical newspaper hypo, and they found a golden rule violation. And it's specifically because you're using exact characteristics of the plaintiff, you're essentially asking the jury to put theirself in the surrogate victim's role. It's not just about, awarding damages in that nature. And what's even worse about this hypo is the continued use of the word you, willing to undergo chiropractic adjustments while some older gentleman touches you in a way that makes you feel uncomfortable.
Ms. Gooden, isn't it just simply an inescapable aspect of monetizing pain and suffering that necessarily requires jurors to do some level of imagining what that pain and suffering is?
No, I think this went past that. If this was just a plain...
Try my question. Isn't that kind of the starting point? That there is no getting away from the fact that jurors have to, and this is why all of these we've all seen dozens, if not scores, of metaphors that try to come up with an easier way for jurors to monetize what pain and suffering is. Aren't all of those simply a recognition of the fact that we're asking jurors to do a little speculating or a little bit of imagining what pain and suffering is worth? And the only way you can do that, because we only experience life through our own bodies and sensations, is to imagine in self what it's like for us.
So, and I think there is a fine line in your question. I think the jury has to absolutely engage in that analysis, what to pay someone. And a per diem argument is okay under the law. You know, the plaintiff undergoes, you know, pain and suffering 13 hours during the day, pay them minimum wage. That is absolutely okay. But this went farther than that. And I think when you include facts in this surrogate victim analysis, that is where the line is crossed.
So let me get this straight then. But by the lights of your argument, fair game to say minimum wage per diem, but you're muzzled. You can't talk about the evidence that's already in the case that the jury has heard about what gives rise to that pain and suffering. How are you supposed to do that? How are you supposed to divorce the per diem part of the analysis and what you're asking the jury to do from the pain and suffering that this person experienced?
But that's not what the plaintiff did here, though. The plaintiff's attorney did not just base it on facts. You know, the plaintiff, you know, had this pain and suffering, this pain and suffering. Instead, the plaintiff's attorney set up a straw game. Essentially, remember the shell game that we used to play as children? And created this surrogate victim. And by created the surrogate victim, it basically allowed asked the jury to put themselves in the place of the surrogate victim. And that's the golden rule violation. And that's what that California case at Collins found. And just moving on to, I want to touch on the disparagement comment. And I'm actually going to start with the second one because I find that the most damaging. And the comment is, you can decide the case based on the greater weight of the evidence and the law as her honor instructs you. And you can use your common sense, or you can decide the case on what Mr. Shell and Dr. Patel told you, but you can't do both. And what is damaging about this happened in rebuttal closing, and it was the very last thing the jury heard. There was no opportunity to respond. And this phrasing essentially pitted defense counsel's credibility against the courts. And
so let me pitch another one. Suppose they had said, the law and the facts are on our side, we should win. The law and facts are not on their side based upon what you've been instructed, they should lose. It seems like that is that denigrating, really?
What you just said is not. But
how is it materially different at all from just pointing out, hey, the judges instructed you what the law is, we ought to win based on these facts, they ought to lose?
It is specifically naming the defense attorney, number one, in the statement, and basically saying you can do what the court is going to instruct you, or you can do what the defense is telling you. And the jury had heard continuing objections as to what the greater weight of the evidence even means. There was constant objections to tipping of the scales. So the jury already knew there was a fight over essentially what the law was on that issue. And so this placed the defense counsel's credibility at issue. It suggested the defense was trying to hoodwink the jury in some way. And then the other comment is attorneys make bigger deals out of these things than they need to. And they were specifically referring to the LOPs. And there was a concession from my opposing counsel in his brief that this was directed to defense counsel. And again, it suggested that the defense did something wrong by focusing on the letters of protection. And you know, it's never acceptable for one attorney to impugn the integrity or credibility of opposing counsel in front of the jury. In fact, this court in Howard v. State said that that amounts to fundamental error. And just moving on, sorry, I just got a weird pop-up on my screen. And moving on to just the last issue is the exclusion of the LOP letter. This letter, even though it was on plaintiff's counsel's letterhead, it was signed by the client, and this constitutes a letter of protection. And it had other basically options the jury could have considered, and it would have been used to impeach Dr. Patel. The other letter of protections that were in the record all said essentially that the plaintiff is 100% responsible for these medical bills, regardless of what happens. This one said something different. It said, at our option, A, distributed on a pro rata basis.
But isn't that how does that in any way contradict the premise that or what was otherwise understood, that the plaintiff would have to pay if funds didn't cover it. It says if the recovery is less than the charges. So,
Correct. And basically the plaintiff attorney would essentially divvy up the funds and pay all the providers on a
exactly. So that you just said it. They're going to divvy up the funds. What does it say happens next? Nothing, right? It doesn't say what happens after the funds are divvied up, does it?
No, that was the end of the letter.
It doesn't say that she does or doesn't have to pay out of her own pocket, does it?
No, it does not. But
right, so what's the problem?
That is a reasonable interpretation of the evidence. And that would have been something that the jury could have considered. Instead, it was hammered home throughout the entire case that the plaintiff was 100% responsible for these bills, regardless of what happened.
So how does this letter change that?
It would have allowed the defense to present an alternative argument.
How is this different than a letter of protection that just says, hey, you know what? We're going to get paid out of any settlement funds?
The others letters of protection, it did. It specifically said it wasn't contingent. And this kind of created like a contingency.
Why is it contingent? How does it make, what is payment of these, those covered by the letter of protection contingent on? So this makes it even less likely that they're going to get recovered funds, right? Because they got to share it.
Correct. And that's the entire point. This letter, it's basically contingent upon recovering. And it says, if the net recovery to our client is less than the outstanding bills that our client owes you, we can kind of divvy this up on a pro rata basis, meaning the doctor is going to take home less money. Whereas if the plaintiff is awarded 100% of those medical bills, the doctor is going to get paid in full. That's the difference. And so by excluding this letter, it prohibited the defense from exploring that and making that argument in front of the jury.
So let me get this straight. So you're saying, I may not be following you, under a letter of protection, that what the jury takes from that is this doctor is going to be paid from any funds awarded. And then this unique correspondence says this doctor is going to be paid from any funds awarded, except that if the funds are less than he and other lien holders are owed, it's going to be distributed on a pro rata basis, let's say. So the marginal difference is in a letter of protection, the jury would perhaps infer that if the recovery was not enough to cover the doctor's bill, he would be in the lurch. But here, it makes it just slightly more explicit that if the funds and the reward don't cover what the doctor's owed, he's going to be in the lurch.
Correct.
But is that marginal difference something? What does that marginal difference give the defendant as far as impugning the testimony of the witness?
Well, it's impeachment. It would allow the defense to make the argument that essentially that these bills they're almost like ghost bills. That's not going to be the ultimate amount that the plaintiff owes. And by prohibiting,
did you all cross-examine this doctor about billing practices and about collection efforts on letters of protection in general?
No, that was not gone into. And I think I'm probably going to be right about my time with 4 minutes left. Judge Lucas?
You're doing fine. You got about 2 minutes before you hit it.
Oh, perfect. And I would like to just go back to the golden rule violation, because I do think that is a significant issue. And it's significant enough that it led one court to find that this was a golden rule violation. Again, the surrogate victim analogy is essentially a shell game. You know, jury, put yourself in the place of the surrogate victim. And that is troublesome because it invites the jury to put it themselves in the plaintiff's shoes. And that is the golden rule. And Florida law is clear that the golden rule violation does not have to be direct or explicit. And that, you know, I urge the court to look at the SDG case and the Bosher Glass case. Both of those were not explicit. Put yourselves in the shoes of the plaintiff. Instead, they were hypotheticals. You know, much like this, there was the SDG case had to do with a puppy story where, you know, a small kid went to the store with $8 and he surpassed all the other puppies and he wanted the sick puppy because it was like him. And the court held that there's no conceivable meaning of this other than a golden rule violation. It was intended to put the jury in the place of the plaintiff. And that is what this news hypo does. And I'd like to reserve the rest of my time.
Got it. Mr. Vaca.
Good morning, Your Honor.
Good morning.
Please the court, George Vaca on behalf of Ms. Bernheim. We're here asking the court today to affirm a judgment entered pursuant to unanimous jury verdict. And let me just, you know, I had prepared something different, but I think I need to go, let me go right to the heart of the golden rule argument. We mentioned in our brief that the Supreme Court has said in Engel that when you're looking at closing arguments and the effect it has upon a jury, that you need to look upon context. And now the case law on what a golden rule argument is that it suggests to the jurors that they put themselves in the shoes of one of the parties. And it's impermissible. This is the reason why it's impermissible. Because it encourages jurors to decide the case on the basis of personal interest and not the evidence. Well, you go back and you read the closing argument that was given in this case by plaintiff's counsel. There are three things that were emphasized over and over and over again: the burden of proof, the evidence, and the law. And the jury was encouraged not to disregard the evidence, not to disregard the law, but to do exactly what the judge instructed them based upon the burden of proof.
Okay, but then we also have a scenario that that's similar to at least we have a scenario in which even though it's not due unto others as you would have done to you, it's at least parallel or reminiscent of cases in which there was not an explicit reference, not explicit invitation for the jury to put themselves in the shoes of the plaintiff. But would you agree that the golden rule violation doesn't require an explicit invitation to put oneself in the shoes of the plaintiff?
I can't deny the existence of the case that she cites with the puppy. I mean, that case exists. So to the extent that case exists and stands for that proposition, of course I have to agree with that, Your Honor. But that's not what happened in this case. So I think that's why we need to go back and take a look at what exactly was this jury charged? What was their responsibility? The jury in this case was to decide, first and foremost, they didn't have to worry about who was at fault. The defendant admitted that. What they had to decide was whether or not this young lady was hurt in this accident and whether or not she had a permanent injury, and then to assess what the nature of her damages were, assuming that they reached those conclusions. The person that they were analyzing that information about was 20 at the time of the trial, but was 17 years old at the time of the accident. So of course, this jury, just like in Simmons, as Judge Warner wrote in Simmons, this jury was doing exactly what the jury was supposed to do. They were supposed to analyze the information about this young woman and to determine what the value of those damages were. And that's what they did. And they had every right to do it. And plaintiff's counsel had every right to tell the jury to think about her circumstances. That was the evidence that was in front of them. It was admitted through the witness stand and in the documents. It was in the medical records. So with all due respect to my colleague, Ms. Gooden, I just think it's a little bit unreasonable to sit there and say, I can't argue what the evidence is about my client in front of the jury in closing argument. I mean, I've been doing this a little while. I've never seen a case where the plaintiff's attorney didn't argue about the facts that were in evidence and talking about how the jury should interpret those facts and ultimately award some type of compensation because of that. And so I think if anything, if we the one thing I didn't hear Ms. Gooden talk about was it's the elephant in the room for her in this case. It's the standard of review. Okay. The standard of review in this case is abuse of discretion on every single one of the issues that they've raised. So no other reasonable judge would have done what this trial judge did when faced with these decisions. Well, we know that's not true, at least as it pertains to the alleged golden rule argument, because there were 3 other judges in the 4th district who decided that a nearly identical argument was not a golden rule violation, did not
Mr.
deprive
Braga,
him of a fair trial. Yes,
can I ask you to shift gears and address the letter of protection argument
sure. That's an
and
easy
the
one.
propriety of excluding the second letter?
Yeah, the actual letter of protection that was agreed to between the healthcare provider and the plaintiff was in evidence. That's exactly what plaintiff's counsel was arguing.
I'm sorry, Judge Loretti. Were you going to say what I was going to say? So why not just admit the other correspondence?
Because this was not what the agreement was. The actual agreement was admitted into evidence. Remember,
But wasn't the lawyer letter also signed by St. Pete MRI?
no, the lawyer letter was sent by Mr. Whittemore's office
Right.
to the St. Pete MRI.
And did St. Pete MRI sign that letter or not?
I do not believe so, Your Honor. I think who signed it was Ms. Bernheim's mother signed it.
Oh, I'm sorry. Forgive me, but it was signed by the plaintiff, just like the provider agreement was signed by the plaintiff.
But it was unilateral. It was not it's not like St. Pete MRI agreed to that. The actual letter of protection was in evidence. It was part of the medical records. So this letter was not the letter of protection. This letter was anything. It was a prelude to ultimately the letter of protection that I understood that they agreed.
Is that the chronological sequence? The Whittemore letter went out, and then later the plaintiff signed.
The letter of protection that's in evidence was the 27th. This letter was dated the 23rd of 2017. And the other thing I think they say, oh, we wanted to impeach Dr. Hall. Judge Lucas.
I'm sorry. Let me ask you one other question.
Yes, Your Honor.
The St. Pete MRI document, was 2017? So Ms. Bernheim was how old then?
In 2017, she was 17 years old.
And who signed the St. Pete MRI document? Did she sign it or did her mother sign it?
Her mother signed it.
So she signed both. The mother signed both documents.
The actual letter of protection?
Right.
I'll have to go back and check. I didn't go back and check on that one, Your Honor.
My recollection, and I could be wrong, is that the plaintiff herself signed the St. Pete MRI document, and the mother then signed the Whittemore letter. And if she was 17, that leads to an obvious question. I don't want to go down too many rabbit holes here, but I'd like you to address. I mean, it seems to me, why not just let the jury see both of these things? I think I share Judge Atkinson's concern.
Well, I think there's a couple things, and certainly what the first thing the judge ruled, okay, was that the letter itself didn't take the next step and say that you would be exonerated from having to pay the full bill. The second thing that the judge said was I think she used the word the term rabbit trail. And she did that in light of an argument, a 403 argument, that this evidence would have a tendency to more confuse the jury than it would to help the jury. And in particular, when you see the way that the defense wanted to use it, right? Because the defense wanted to cross-examine and impeach Dr. Hall. And Judge Lucas, they did ask Dr. Hall about LOPs. There's a whole extensive part of his testimony about LOPs. So they didn't ask all the things that the Supreme Court in Worley said you could go ask about, but they did ask about LOPs. And what they wanted to do was they wanted to impeach Dr. Hall. And remember, Dr. Hall testified that he worked for a medical practice, that he doesn't do anything with letters of protection. That's all done through the medical practice. All he does is treat people. But they wanted to impeach Dr. Hall with a letter of protection that wasn't even from his employer. It was this letter. They weren't using St. Pete MRI. He's not employed by them. He was employed by the surgery consultant company. And so they wanted to use this to somehow impeach this doctor who was testifying about the LOP that was issued by his employer. Totally separate entities. That's what they were trying to do with this. So the judge, in my opinion, acted reasonably in weighing this out. Is that going to confuse the jury? An LOP from some other third-party provider?
Was there any insinuation, evidence, or substantiation to the idea that he would have been aware that the council was going to distribute funds in this manner? He or his employer?
There is a letter of protection with Dr. Hall's employer. It's in evidence.
No, I know, but the letter we're talking about, though, you say, well, that was not. It's obviously it's sent to St. Peter MRI, and which is not the witness's employer. The witness that you're speaking about, that you're saying the plaintiff wanted, or the defendant wanted to impeach, or was there any evidence that witness would have been aware that the distribution of funds would have been consistent with the letter we're talking about?
No, the witness testified that Ms. Bernheim would be responsible for 100% payment of the bills, regardless of the outcome of her case.
Okay, so then there are. Maybe you're not following my question. My point is, you're making the point that this was not germane to that doctor or that doctor's medical group, right?
That's one of the points I'm trying to make. Yes, sir. And
my question is, the plaintiff, the defense wanted to make the point that, well, this would have affected the doctor and his medical group, because this is the way that the funds would have been distributed, and there would have been even less than what would have been under a normal letter of protection, because he was going to have to share it with other lien holders.
But that was not the agreement that he was operating under, Your Honor. The agreement that he was operating under, that had been obtained through his employer, was the traditional letter of protection. So he, regardless of what St. Pete MRI would have received or not received, it would not have made a difference to his employer, because his employer was to receive 100% of the bills, regardless of whether Ms. Bernheim won her case or did not.
I think if I understand you, Mr. Vaca, you are likening the what we'll call the Whittemore letter, the follow-up letter on the letter of protection, to like a unilateral offer to modify a contract, just kind of in the ether. It doesn't. This is something that they were offering, but it has no legal significance, because St. Pete MRI never. There's no evidence St. Pete MRI actually agreed to this. Am I understanding your argument?
Yes, Your Honor.
Or the entity for which the witness actually worked.
Yeah, they had a different agreement. The agreement that for that entity was a traditional letter of protection. So this letter is only germane to St. Pete MRI if it's germane at all. It has nothing whatsoever to do with Dr. Hall.
Right, and so that's why I was wondering, and Ms. Gooden will maybe let me know if there was any evidence that they had, or they would have adduced, to say that, well, this witness or his or her employer would have known of the intention of the council to divvy up the funds between all these folks who had a supposed right to it under letter of protection or lien, and which would marginally change the motivation of the witness. And I have to assume, and Ms. Gooden can correct me if I'm wrong, the rationale would have been to suggest to the jury that because in other words, the funds were even more scarce than they would be. You said, well, she has to pay for everything. Well, that just is red herring, right? Because the whole point is, yeah, of course, she has to, usually the patient has to pay for everything. Letter of protection means I get a guaranteed payment right out of the recovery, and it just goes without saying that, yeah, okay, well, the point of the impeachment, the underlying rationale is, hey, this witness is more inclined to want to produce testimony that would support the case because this witness is an interest in getting guaranteed funds rather than having to hound this patient. The whole point of a letter of protection is probably the patient doesn't have insurance to begin with. And so my point is, I'm just making their point, which is this makes those funds even more scarce. Like, wow, I got to compete with other lien holders for these guaranteed funds from the recovery.
Well, let me back up and answer your first question, which was there evidence?
Well, I'm glad you're all my questions. I don't know if I do. Okay.
There was no testimony about whether or not he was aware of this particular letter or whether there was even an agreement with St. Pete MRI upon which this letter is the accurate reflection. There was no proffer. So when they were arguing about all of this, there was no proffer. They argued about it on the second night of trial. They came back on the next day and they played the video of Dr. Patel. But there was no proffer of evidence that Dr. Hall, who testified that morning, knew anything at all about this. So even if in some wild way this document was relevant to impeach Dr. Hall, it's not preserved by way of any type of proffer or any type of evidence in this record, at least to I just read this again yesterday. I didn't see anything at all where there was anything that Dr. Hall knew about what St. Pete MRI did or didn't do. That wasn't his thing. He was the one who was providing her with the steroid injections. And he looked at MRIs, but it had nothing to do with him. I hope I answered your question.
I guess I could say, assuming knowledge on the part of whatever witness was to be impeached with this letter, would you concede that the normal rationale for impeachment may have been made even better by this letter because the funds that an attorney would argue were the motivation for the testimony were even more scarce due to the intention of the lawyer to distribute it among other lien holders?
I think I would defer to how the trial judge saw it, which was this letter doesn't say what's going to happen in terms of if there's insufficient money to pay back all the funds, whether or not she's still going to pay. And that was the reason why she kept it out of evidence, because it didn't say what was going to happen. And she also thought it was probably—
Isn't the important part of a letter of protection not that the plaintiff is going to have to pay, but the fact that the plaintiff has to pay, but that payment could come from there's an agreement that it will come from the award? I mean, isn't that in other words, we're maybe focusing on the wrong part of the normal scenario of an impeachment with a letter of protection. You say, well, it all depends on whether the plaintiff still has to pay. Isn't what's more important for the purpose of impeachment that the witness or his or her employer has a right to payment from an award, regardless of whether the plaintiff would be otherwise required to pay?
Well, I think that the logic that the Supreme Court used in Worley to allow impeachment based upon a letter of protection is the financial incentive or the argument that there's a financial incentive to come give the testimony and persuade the jury to give an award. I don't think that, that's undeniable. That's clearly what the Supreme Court was thinking when they wrote Worley. The question is whether or not this letter that doesn't say what's going to happen at the end is relevant to impeach a doctor who is not employed by this facility.
Mr. Vaca, you're coming up on your last minute.
Okay. The last thing I wanted to ask the court to look at, in looking at this argument as a whole, the one thing that again, we haven't heard anything of, is that the argument has to be so highly prejudicial and inflammatory that it denied this defendant's right to a fair trial. And most respectfully, she used the term apples and oranges, and I could not agree more. This argument, this closing argument, and the ones that she presented that were reversible error, the two by Mr. Simon, the one by Catfish Abbott up in Jacksonville. Okay, I've heard those people speak, and I can tell you, no disrespect to my trial lawyer client here, but if it was intended for this closing argument to be highly prejudicial and inflammatory, it didn't succeed in that. He didn't get what he asked the jury to bring back. This isn't a situation where the jury went crazy because they were provided some ridiculous argument that was saying you should be apologizing for your behavior and all this. This is not what happened in this case.
Mr. Vaca, we'll need you to wrap up, okay?
Yes.
Thank you. So for those reasons, we would ask that the court affirm the judgment entered pursuant to this jury verdict because the judge did not abuse her discretion in any way. And thank you very much for your time today.
Thank you, Mr. Vaca. Ms. Gooden, you have your full 4 minutes.
Perfect.
So
I just wanted
could you
to
start, Ms. Gooden, with where I think Mr. Vaca was going at the end of his argument, which is, the plaintiff asked the jury for $2 million. They awarded $125,000 roughly. And so if I'm not misapprehending his argument, I think it is that no matter what, if the cases that you rely on, et cetera, the jury went crazy after receiving or hearing an argument, getting or not getting evidence. Could you address that sort of on the whole?
Yeah, because it gets to the harmless error standard in special. And the Florida Supreme Court in special told appellate courts that the court is supposed to look at the effect of the error on the jury and to avoid engaging in an analysis that looks only to the result. So the amount of money is irrelevant. You have to look at the effect on the jury as a whole. And so how you do this?
Is that really true? I mean, can you really make that kind of a categorical response? Suppose this jury sent back a nominal $10 verdict, right? I mean, would you really be, yes, that there was negligence here, but she didn't have any damages. She's fine. Would you really say that is just out of bounds? You just don't even consider that against a $2 million ask?
Well, that is a very extreme example, but
you made a categorical response, so I'm holding you to it.
Yeah. So based on special, and I think it was the Cuculino. Sorry, I just butchered that word case that my opposing counsel relied on in his brief from the 3rd DCA. I believe it was R.J. Reynolds' case. What the court does is actually look at each item on the verdict. And especially, did the jury find for the plaintiff on every single line item? And that's exactly what happened here. This jury found for Ms. Bernheim on every single line item. And that in and of itself shows that my opposing counsel and the plaintiff cannot show that this error was harmless.
Isn't there also a sort of a parallel comparison, or I should say calculation, 2 million down to 125 million, but another comparison could be nominal damages versus 125,000 damages. That's a pretty big differential too, depending on what socioeconomic status you are. 0 to 125,000 is a pretty big difference. It's not as big numerically as 2 million down to 125, but should we focus on that as well?
I think ultimately no, because time.
Well, my point was that, in other words, if we're to look at all to the effect, which you're saying we shouldn't, we should look at the result. The result could have been different The result could have been a nominal award as opposed to $125,000 award.
Correct. That's
Um,
absolutely correct. And again, if you tie the harmless error analysis to just what the plaintiff asked for closing, you're going to run into due process issues for the defendant, because we use this hypo in our brief that say the plaintiff attorney asked for $1 billion. Anything less than $1 billion is going to be harmless according to the plaintiff. And that can't be the case. That's not Florida law. And so I think we do have to look back at the language that was used in special. And
Go ahead.
Oh, I was just going to say, I wanted to make another point. Mr. Vodka said, there was essentially this evidence about separate entities and he didn't know anything about these LOPs. That absolutely was not true. I want to point the court to page 301 to 302 in the transcript and 380 to 381. This is the plaintiff's direct and the plaintiff's redirect of the doctor, where he specifically talks about the contract and this LOP. That open.
He talks about the letter, the distribution.
Correct. He talks about the LOP that went into evidence. And
the operative LOP, yes.
Correct.
Talk about, was there any testimony that suggested an awareness of the scheme, the distribution scheme, or whatever you want to call it, set out in this Whittemore Law Group letter?
Well, there was a follow-up question during redirect that basically says, you understand that if this jury doesn't award a penny for medical damages or medical bills, that she still owes every dime. And then you realize a risk that your employer may not get paid if this jury pays zero. And he said,
my understanding of the potential rationale for impeachment pursuant to this letter is that it essentially is like LOP plus. Usually the LOP argument is, well, you know what, if there's an award, you get paid guaranteed out of that award. Here it's LOP plus, which is those funds are even more scarce. So that's even more of an incentive to testify in a way that increases the damage award, so that whatever portion of those scarce dollars that are part of the award go to you or your employer. Was there any evidence that the witness intended to be impeached by this evidence understood anything having to do with this scheme of distribution pursuant to this letter?
No, there was no evidence. I mean, that evidence was just marked for identification and basically proffered. My opposing counsel said there was no proffer. The letter was proffered.
Okay, well, he meant there was no proffer to my question, which is the letters to St. Pete MRI. The witness intended to be impeached worked for another employer. And so I believe what Mr. Vaca was saying, there was no proffer of evidence that the witness intended to be impeached had any awareness of this letter or its contents.
Not of the letter from Whitmore. But again, it was excluded, I believe, before this.
Ms. Good, go ahead and wrap up your answer. I've let you go a good bit past your time, so wrap up your answer to Judge Atkinson, please.
Yeah, absolutely. That letter was excluded. And so defense counsel did not get into it, did not ask anything that could have insinuated it, because he didn't want to run afoul of anything as well.
So you're saying we don't know whether there could have been evidence adduced to about the awareness of this witness?
I believe so, because I think the defense
there's nothing
counsel,
in the record suggesting that this witness or his employer would have been aware of it.
I believe he would have been, and the reason why is because he was aware of the other one. Again, in page 380, he talks about that.
He was aware of the other one because that was to his employer.
It was to St. Pete MRI.
The other one.
And this one also is to St. Pete MRI.
Okay.
Both of them were both to St. Pete.
The admitted LOP was to St. Pete MRI.
Correct.
Okay. Well, we'll look at I'll look back at the record. Thank you.
Thank you, Ms. Gooden.
Thank you.
If you all please exit the virtual courtroom, we'll call our next case, Parsons v. Culp.